Good evening. We'll call to order the work session of the Apache Junction City Council. Appreciate your attendance here this evening. I'll ask for a roll call.
Mayor Coleman.
Present.
Vice Mayor Eck.
Here.
Councilmember Deeds.
Here.
Councilmember Ensalata.
Here.
Councilmember Severs.
Here.
Councilmember Sippel.
Present.
Councilmember Waldron.
Here.
All members present at the quorum, Your Honor.
Thank you. Item number 3 on the agenda, discussion on master development agreement for Superstition Square downtown project between City of Apache Junction and AJ Town Center LLC. And Mr.
Your Honor.
Councilman Waldron.
Before we get too far along tonight, I'd like to address a concern that some folks have expressed to me. And the concern is that the city manager did not negotiate with the real estate investors a deal that he could advocate for the council. The city manager did not do that because that was not what the council directed him to do. What we did tell him to do was to review the proposal line by line, express the investors' concerns or issues with that proposal, and to bring the investors' proposal back to council. The investors were told us that time was of the essence, and we conveyed the same to the manager. That direction was given on January 20th. He had the investors' proposal back to us by Friday, January 26th. He may not have done what some folks wanted him to do, but he did what the city council had directed him to do. So thank you for that.
Okay.
Your Honor.
Councilman Severs.
We had an issue come up a while back regarding the disposal of the weapons, and beginning of that meeting, we discussed that our chief, we believe, had done nothing wrong, and we'd like to keep the meeting positive and not let our chief get beat up. And I believe very strongly the same way tonight about our city attorney and our city manager. As David just said, everything they have done, every point, every word, every issue has come from the council. They're not ruining this deal. They are not doing anything wrong. They're doing what we have requested. And I'd just like to not focus on that, but focus on what we can do to move forward here and do it in a positive way.
Thank you, Councilman, for a second there. I thought you had jumped to the next item.
I did too. I'm like,
Hey, man, that's the next item. What are you doing?
George, do you want to kind of introduce item 3 to us? I know it's got our name on it, but...
The real estate investment group has provided a proposal to the city council. As Councilmember Waldron mentioned, the city attorney and I sat down with them, expressed issues and concerns to them. I don't know that it has legal meaning per se, but I think they've attempted to give you their highest and best offer, and we have brought that forward for your consideration.
Okay. Members of the council, you have had a chance to take a look at the agreement, and are there questions or concerns?
Your Honor.
Councilman Sippel.
You know, I have a few, and I had stressed them at the business meeting that I attended last week. And one of them still is, you know, as I've gone through those 73 pages of the proposal, I did not see where there was a description of what was actually going to be built, where it was going to be built, and if and when it would be built. I'm just curious, is that in there somewhere that I missed?
You did not miss it. In many municipal incentives agreements, you will know who the developer is, what the project is, what the project thresholds are for reimbursement. This proposal is not that kind of construct.
Your Honor.
Councilman Waldron.
I've got a question. There's in the agreement, in several places, actually, there's a statement that says that the city will not unreasonably withhold approval or any number of things within the agreement. What is meant by unreasonably withhold? I think probably for Joan.
Mr. Mayor, Mayor of City Council, Mr. Waldron, I believe that would refer to any action that the city does not do. If it does not approve something, the argument would be, okay, you're unreasonably withholding it. And the standard would probably be before an arbitrator or a mediator or perhaps a judge if it got that far. We would hope it never would get that far. It would probably be in a municipal setting, that would be the focus, whether it's a commercially reasonable action by not approving it. And that could be from staff also, any staff actions. Also, I believe, I'm not sure, I think I know why it's in there, and it's to assist the real estate investor so that future councils would not unreasonably withhold actions. I think there was a concern about future actions by future councils.
From my perspective, it adds an opportunity for a legal challenge, and because that legal challenge potential exists, it enhances the developer's negotiating position.
George, can I go back to the question that Councilman Sippel asked you? Normally, in a development agreement, it's either the property owner that's going to do the developing, or it's someone who has an option on the land to buy it based on being able to put in a project. In this case, they have told us that they're not the vertical developers, they're the property owners. Are we looking to do something in a proper sequence, I guess? Wouldn't a development agreement normally be made with the ones who are actually going to build? In most models, and I just draw from the models that we've had here in town. I remember we had a development agreement for Walmart, and is that the only one?
Earnhardt.
Oh, and Earnhardt. And in both of those, we had the people that were going to actually put in the development there. And I don't quite honestly remember if they owned the land at the time or if they had an option to buy it as they were putting forth their plans and wanted to discuss with the city. But in both of those models, the city knew very specifically what we were getting in return. And what I'm wondering is if this agreement does not have any of those points in it, is it because this is far earlier in the stage than those other two models were? Do you understand what I'm asking you?
I understand what you're asking me. I guess I'd have two.
I mean, is this is completely different than the other development agreements that we've worked on in that respect, in that we're being asked to commit some city resources, but because we don't know who the end owner will be or developer of the actual project, we don't have specifics of where or what will be built or when.
We've had some discussions with outside legal counsel, a niche expert in development agreements. He said that this kind of agreement for this kind of project is not something that he is familiar with in his experience. You do have occasions where so-called horizontal developers, contrasted with vertical developers, someone who's going to build something, as you just described, seek entitlements for the land. Those entitlements limit or reduce the risk of the developer. They know what legal parameters, what legal framework will exist if they were to buy the property and if they were to do a development. Those entitlements add value to the property, and that's the model that's being pursued in this instance. I think the benefit that they're suggesting is that we can have a sense of basic urban form, that there would be a main street that runs through the triangle, if you will, from Idaho to North Apache Trail, that we could seek an aesthetic standard, that we could have some design guidelines and create hopefully a unique sense of place, and that we could work towards a pedestrian-oriented mixed-use downtown. And that their suggestion is, their proposal is that this document would help us achieve those three objectives.
Okay.
George?
So is this a common model that's being proposed with the entitlements and?
The advice that I have received is that it's not a common model.
Okay.
All I was going to ask is, you said design guidelines. Is that considered to be design standards in this agreement?
The Main Street organization worked with city staff. Design guidelines were developed. The city council adopted a design dictionary, and Kathy, commercial design guidelines, is that the title?
That's correct, in 2004.
2004. Those are guidelines. That work product is currently not referenced in the proposal that you have before you.
So you're saying they're not being considered standards?
They certainly are not standards that could be, that would compel a future developer to comply with. No, they're currently guidelines, and they're currently not referenced in this proposal.
That's my problem with the whole design guideline issue, is it's not a mandatory thing. I would assume they'd build a fine product and all that, and maybe I'm being a little too paranoid on that, but because it's word guidelines rather than standard, I would...
Now, this agreement does provide for the future developer to bring forth to the city council design standards, and those would be standards that you would consider your approval not to be unreasonably withheld, I believe is the language.
See, that's worse than asking the design.
But once those standards were then adopted, and city attorney, correct me if I'm wrong, those standards would then be standards. They would not be guidelines. They would be mandated.
All right, great. Thank you.
Councilman Wong, or Dietz, sorry.
I'm not sure, George or Joel. I understand that they'd like to propose a community facilities district and also another district, an enhanced municipal services district. Can you explain what those are and how they're going to work?
That may take a few hours, but you want a summary, essentially.
Cliff notes, Joe.
A community
Digest.
facilities district, or CFD, as it's noted in the agreement. It's a special district. It'd be a political subdivision of the state, so it'd be a separate entity from the city. It'd be based on a district formed within the city limits on a petition of the property owners following a public hearing. At the public hearing, the council decides what properties will be included. There could be properties that the real estate investor doesn't necessarily own, and they could include it in the plan. However, that would be up to council whether those properties would be included. That is in the statute, 48-701. The individuals who don't want to be in the district, they have a right to protest, and there's a hearing process for that. If the council then goes ahead and approves the district with those people in the district or their properties, they can then go to the Court of Appeal directly. It's one of the most unusual statutes I've seen. It's a direct appeal to the Court of Appeals of Arizona to try to get out of the district. The CFD must be approved at an election of the property owners if 100% of the property owners do not sign the petition, and qualified electors residing within the district. So what you'll have is you'll have one election with essentially two separate ballots that are coded. One would be for property owners, one would be for just residents who live within the district. It's an unusual election. It hasn't been done before, really, in this city. But That's what a community facilities district election is.
Yeah. And the advantages of having that would be?
Well, the advantages would be to finance the public infrastructure of this project.
Through bonding or what have you?
Correct, through bonding.
Okay.
And it's a common financing mechanism in Arizona.
Okay, so the Enhanced Municipal Services District, this
That
kind
is,
of confuses me just a little bit.
Excuse
Does
me,
this provide just for enhanced services just in this area? Some way of taxing or generating revenue through this special district to provide more services in that area?
the Enhanced Municipal Services District comes under a different section of the statute, and it essentially is an improvement district. It's not a community facilities district. The difference is it would be a district that the city sets up, kind of like a streetlight improvement district, where you don't have an election. You just have the council approving it. And you can still tax the properties for the costs, essentially. And it's for enhanced municipal services, and that essentially means let's see, hold on a second, I have it right here. There would be authority for the city through tax assessments to provide public service within the district at a higher level or greater degree than provided in the remainder of the community, including such services as public safety, fire protection, refuse collection, street or sidewalk cleaning, or landscape maintenance in public areas, planning, promotion, transportation, and public parking. That's
Which would be, they're asking for an increase in these services for this area.
Correct. That would be,
And then taxing so much per $100 valuation.
Correct.
In your property taxes to pay for that, just for this area, not any other areas within the city.
that's one option, and that the proposal would allow for you to set up a community facilities district and/or a enhanced municipal services district.
Okay, I thought they had wanted both of them. Thank you.
Well, I think you could do both. You could do both, absolutely.
Councilman Insulaco.
The city has an obligation to use sales tax to pay other expenses. How does this proposal fit with those other obligations?
In the event that sales tax from the project area was required to be paid by the city, then we would have to pay it, and we would either need to increase revenues or reduce expenditures. So if we had $1 coming in sales taxes and we were using it for police and Parks and Rec, and that $1 then had to go for the backup for reimbursement for the infrastructure, then we don't have that $1 anymore for parks and PD or whatever example I used. And so we'd have to either find some other money to pay parks and PD, or would have to reduce them $1.
George?
Does that affect, excuse me just for a second, does that affect our bonding capacity? Does that encumber all of those monies, or no?
I think that the agreement references general obligation.
That's correct.
Indebtedness of the
That's correct.
city.
So it could.
Works on the same way as any other loan, right? Debt ratio percentage?
I did ask Mr. Ruby the same question, and I think he believes the way it's written, it could do that, to answer your question. It would obligate.
It would be a potential obligation of the organization, and so anybody that's going to look at your ability to repay them is going to know who you have other obligations to pay. So they would want to look at this arrangement and assess the fiscal impact on their loan or their bond to us.
Your Honor.
Councilman Waldron?
As a follow-up to that, in the agreement, it states that all transaction privilege taxes imposed are actually received from the city from all other sources. That includes then the 2/10 capital facility improvement tax? The 2/10?
I believe it would cover that, yes. So that would be, if you don't fund the CIP fund because you're essentially paying for the public improvements, well, a portion of them, you're going to have to find the money somewhere else to pay the CIP fund.
Could we remove just that 0.2% from the agreement? Is there a way to do that?
You could put language in here that does exempt monies that are paid for the capital improvement projects.
That are currently earmarked for that? Or,
I think you could.
okay, that tax is supposed to sunset in 2010.
That's correct.
If the council in 2010 were to want to continue that program, could it be renewed without affecting could the agreement be written so that it did not affect a renewal of a 0.2% for a,
Yes, legally it could be written that way, whether that's a deal point. So that'd be a city manager question if that were the deal point. Actually, it's a council decision, but legally it can be written that way, yes.
okay.
George?
Councilman Severs?
So you're saying if we've got tax money that's already allocated to other things, this agreement would take that money?
In the event that you needed a backup, the core of this agreement is to provide for the provision of infrastructure. Infrastructure that the city would normally pay for, and infrastructure such as we call them off-site improvements that the developer would normally pay for. So it's paying for the city's portion and the developer's portion of infrastructure. If the primary funding source for that repayment were to be unavailable, then it calls for sales taxes from the project area, which is owned mostly, but not exclusively, by the Real Estate Investment Group. It calls for those sales taxes to serve as backup means for reimbursing for that city and developer infrastructure.
Your Honor,
Councilman?
a two-part question, Joel, I think it's for Joel. In the agreement, the developer requests the city to, let me get it here real quick, use applicable laws to get property from other property owners. I think I know what they're talking about, and I expressed this too last week. What does that refer to, and do we know the properties that it's going to affect in this agreement?
I believe what you're talking about is on page 8 of the agreement.
Yes.
Under section 3.9, acquisition of real property for public improvements.
Yes.
And I think the question there, what does applicable law mean? I think the intent is if the real estate investor or at one point the developer decides, we need that piece of property for the public improvements. We've tried to negotiate to obtain that from the owner, and we can't obtain it. So city, we'd like you to help us do that. And I think if, that means the city would have to go and try to negotiate, pay fair market value or more, or whatever the investor would want us to do. And if we can't do it, I think this agreement essentially says we would have to use our best reasonable efforts to follow applicable law. And in my mind, that probably means condemnation and eminent domain powers, because that's how a city can essentially take property for public purposes. So I think it does obligate us to do that at one point.
Do we know what those properties are?
No, that's not listed in the agreement. In discussions, we did discuss it with the investors, and I think there is one piece of property that they've tried to obtain from a particular individual, and they haven't been able to. And I think the intent was for that particular piece, but that is not specifically listed in this agreement.
So for us to go and start negotiations, and then if we can't get anywhere with them, then to just take that piece over.
I believe that's what this agreement would require us to file a condemnation action.
second part to that question, thank you. It talks about city abandoned right-of-ways and easements at no cost to them. What does that mean?
That's also on page 8,
Right.
3.10 abandonment. Typically what happens is, let's use an example, federally patented easements. There's a process to extinguish federally patented easements in the city. The process is going through the Public Works Department. However, we have done that in the past on plats, and I believe through rezonings without going through the process. And I think it is legal to do that, to extinguish rights-of-ways, or I'm sorry, to extinguish easements. In this case, this also talks about rights-of-way. So in my mind, that would mean dedicated right-of-way, dedicated roadways. And if the real estate investor would like us to essentially, abandon that right-of-way because they need it, I think this would say, okay, we can do it, and they get it for free.
So we're giving them free land.
But I believe you can do that in a development agreement, in a negotiated development agreement.
Okay.
Councilman Sears.
I've seen requests for abandonment of easements and right-of-ways before that are not able to happen. What if that is the case here? What if there's one that can't be abandoned? Are we under any obligation to make it happen?
Well, I don't know what you mean by can't be abandoned.
Federal patent easements, we've had them before where we,
Right, but that's a council decision.
I
Whether,
was told that there's certain ones that can't be.
yeah, they're.
well, if there are, say it's a state highway, and the city doesn't own it, so the city can't abandon it.
There's several in the city limits.
Well, also, if they're being used, and it's the only access to particular properties, then if you were to cause an abandonment, now we'd be subject to probably a 207 issue, to say the least, and probably some other property issues. That would be it'd be unconstitutional to probably take someone's land, take the frontage of land, and now someone cannot get into, can't have public access.
Joe, we can't abandon utility easements, for example.
Correct, because the city does not have any utilities. The city has not gone through the 9514 election to do so.
Does it differentiate?
And I don't know,
No.
I don't know when they would ever ask us to abandon a utility easement, but what if they did?
If the
What obligation are we under? Yeah.
Under this provision, I believe, I think it talks about rights-of-way easements. It doesn't say what kind, and the only kind the city would have would be a roadway easement. The city has no right to extinguish a utility easement because we don't own the utility. It's the utility. SRP would own
Right,
the...
so we couldn't do it.
What if there's a
So-
sewer line and for some reason they need that abandoned because they're not gonna use that one anyway, because they need one 3 times as big or somewhere else, and they need that easement abandoned? Do we have the capabilities to abandon
I
that?
do not think we could condemn a existing
The sewer district
utility
would have
owner.
to.
I think the sewer district would, they'd have to make a deal with the sewer community facilities district.
But if they're putting one 3 times larger, they probably have some pretty good negotiating power.
Well, and they should do that, then they should pay the expense.
Well, that's what I was getting at. I have just a couple technical questions. Again, I don't understand best reasonable efforts. I don't get it, Joe. What does that mean, best reasonable efforts? It sounds like a lawsuit to me.
It's in there a lot.
Yes, and we did talk about that with the real estate investors essentially.
That one and unreasonably withholding.
Okay, well, as to the best reasonable efforts, it's the same analysis. Essentially, in this case, city staff or the council, where appropriate, must act with due diligence and good faith. I think that is the meaning of that in a municipal setting that's commercially reasonable. And the way to prove it is you'd have to, if we got into a dispute, which I hope we would never get into that kind of dispute, but it's possible. If we got into that kind of dispute, we'd have to probably put up an expert to say what a commercial, best reasonable effort means. And I think that the reason I think they put that in there, they don't want the council or a future council going off and making arbitrary and capricious decisions. I think that's why they put that in there.
Your Honor.
Councilman,
One of the problems that I have with that, and I've raised the question once before, we keep hearing that the council has the ultimate say in what does or does not happen here. We have the final say in what goes in or what does not. I asked a question a while back about downtown Chandler, that, downtown Chandler has these beautiful new yellow and purple buildings in the heart of their community. What if they propose, we're going to put in some yellow and purple buildings, and we don't want that? Are we being unreasonable? Under this
No, we're not, because
document,
they're not under standards, they're under guidelines, right?
So if we deny, my understanding is if we deny yellow and purple buildings, they could say that we're being unreasonable and force us to do it anyways, or sue us, or litigation.
Well, but as going back to the Vice Mayor's question earlier, the proposal does include a provision wherein the developer proposes design standards to the city council, and the city council can then vote to adopt those standards. Again, your approval to not unreasonably be withheld.
A lot of these technical words just seem, they're kind of scary if we just, it sounds like we're dwelling on, I know me, I'm dwelling on a lot of the technical, because it, best reasonable efforts and that. And maybe it's overkill, but it's just a concern because it sounds kind of weird. The phrase materially impaired developer's ability to develop the property.
Well, that goes back to the...
Can I answer that one? That one deals with section 3.11, starting on page 8 through 10. And it's in different provisions. This is applicable laws. And I believe what the real estate investor wants in this case is, if the city passes future ordinances, future resolutions, future international building codes, I think what they're afraid of is, at least the way it's drafted, let's take building codes first. Building codes, they are willing to let the city, or actually for 10 years, the city cannot enforce the building codes, any
It's
new ones.
ridiculous.
After that, we could.
That's ridiculous.
I think it even
But
states in
there's
there.
another question in there. Does it materially impair the developer's ability to develop the property as contemplated under this agreement? And that comes under some of the other sections where we talk about other land use or other resolutions, ordinances, regulations. There's also some exceptions in here. If it's a health safety type of issue, then we can enforce those against the construction that's being done.
But not like conservation or something, which we're moving them closer and closer to all the time,
Kathy,
such as this building.
Isn't there a new House bill, Kathy, that's could be going through as far as building green to some extent or something along that nature?
There's two right now, and there's still time to introduce legislation. And there's House Bill 2252, which repeals the prohibition that municipalities right now have to have their own plumbing codes. Right now it says we have to comply with the state plumbing code. If this goes through, it repeals that, and then a municipality could have its own plumbing code. But even more important than that is H 2275, which basically says, in summary, counties and municipalities must adopt and annually update a building energy code for residential and commercial construction that conforms to the International Energy Conservation Code adopted by the International Code Council.
Joel, how would that, if that was to go through and pass, how would that affect?
How would it be
Or would
enforced? Could it be enforceable for the first 10 years? There's an argument that it could be because it's a health safety type of law. And once again, this agreement allows for disputes. Before you go to court, you have to go through an arbitrator, mediator provision, and it'd be up to probably an arbitrator to decide
But
that.
for the most part, for the first 10 years, it wouldn't be,
For that,
unless it was a,
I just don't know how building codes aren't health and safety issues.
yeah.
well, the argument would be these are health safety issues, I'm sorry, you're going to have to comply with it. And then if they don't comply, then we get into the dispute resolution provisions.
See, that's where it just makes the agreement that much more difficult.
Your Honor, Your Honor.
Yeah.
You know, it seems like when we're talking about this, everything goes back to an arbitrator, or there could be
Yeah.
legal action. My concern is, within this agreement, who is going to pay for all of this legal action if it goes forward? Who pays for all that in this agreement?
Mr. Sipple, if there is a dispute and it goes to an arbitrator, I believe the provision talks about a split on the fees for the arbitrator. Now, if it goes to court, and if they don't like if we don't like the result, we go to court, I believe the prevailing party would have to, would win their attorney fees. And that's the case in any litigation, pretty much. The prevailing party would win their attorney fees.
But when I'm looking under section 8.2, the agreement cover costs for legal challenges.
Says taxpayer.
It's,
Right.
Now, that's specific as to, that's on page 15.
yeah.
That's specific as to the tax increment value, whether the city no longer receives a tax increment. If it does, then that's good. Then we don't have to resort to sales tax. If it doesn't, and the city decides we don't want to challenge it, this proposal allows for the investor to say, okay, we're going to challenge it, and if there's any attorney fees, then they are subsumed in the public improvement costs.
So our taxpayers pay their legal fees.
In the end, that could happen.
For how long?
But once again, it's on the, well, for as long as the agreement is in, the term of the agreement, 2031.
So for up to 23 years, we'd be liable for their attorney fees.
There's no cap on the legal expenses.
But it would be the one-time challenge on the TIF. I mean, it's fair to say that this isn't a challenge that will go on forever. The court would make a ruling on the TIF, the prevailing party, whoever that may be. It's not like we're going to have a challenge after challenge after challenge on the TIF.
This compels us to
just
defend it, and it doesn't say that it stops at the first court decision.
No, I understand that, but if there is a challenge to the TIF, and let's say the court rules that the TIF is legal, I mean, it's pretty much over at that
Well,
point.
actually, the trial court, that can be appealed to the Court of Appeal,
Sure.
which can be appealed to the Supreme Court.
But my point is, it wouldn't necessarily carry on to 2031, I guess is what I'm saying.
Well, the Supreme Court is pretty slow this time of decade, I don't know.
It could go on to the Supreme Court, and as we know, that could certainly be
I think
many years.
We're not just talking TIF here. We're talking not reasonable withholding and all these phrases in here that we were concerned, best reasonable efforts.
What page are you on, Mr. Eck?
I'm just going through it. I mean, all these little sayings that we all seem to have hang-ups with because they
Well, I was referencing the 8.2 that talks about the tax.
unreasonable withholdings. Would they not apply to that also? Best reasonable efforts. If it does go into litigation, are we not in the same?
I think if it's a best reasonable effort type of argument, that we're not, the council
Then
didn't use that.
then we're on our own. They're on their own.
No, then I think it would go to an arbitrator or a mediator, and if that doesn't work, then we can go to court, and I think the prevailing party could win their attorney fees. It's not guaranteed.
Okay. So 8.215 is TIF only.
Yeah.
Right.
Okay.
Your Honor, one more, since we're talking about taxpayer money. Does this proposal allow for taxpayer money to be paid out before? I mean, is there money to be paid out before actual construction of taxpayer dollars?
It does not require that happen, but that scenario could happen. If you'd refer to Exhibit F, page 68, under paragraph 3, essentially what that says is that once the minimum improvements are accepted by the city, and those being the main street between North Apache Trail and Idaho, And once the real estate investor has submitted and received approval of a phased development plan incorporating 100,000 square feet of retail, they can then access public improvement.
Once they submit a plan, it's just a plan.
That's correct.
So there's no, I don't understand why there is no commitment to build anything. There's a plan to build something.
That is correct. There's two other provisions that I would refer you to. Exhibit C on page 56 indicates that a developer is to submit a PDP, a phased development plan, within 24 months of the recordation of the agreement, and to have submitted construction documents within 30 months. And then if you look back at section 7.1 on page 13 of the proposal, it indicates that after the city has approved the construction documents, quote, developer shall begin and shall thereafter diligently and in good faith complete the development of each phase of the improvement and the design, construction, and installation of each phase of the public improvements.
I have not seen, or maybe you can refresh my memory if it's wrong, which wouldn't be the first thing. But in development agreements where we've rebated or paid for the offsite and things of that structure, it was always done, rebated or reimbursed to the developer after it was done.
That's correct. That's you're talking about the Walmart. An example would be the Walmart agreement, I believe.
Well, yeah.
Right.
I have not heard of any other agreements, even in other cities.
Well, this is
where
the retail.
They're getting paid.
I'm sorry. Go ahead.
They're getting paid without producing anything.
The transaction privilege tax payment is a backup in case.
I understand that.
Okay. Well, this is a different type.
But the reimbursement for the offsite that they're doing normally comes after the offsite is completed.
Not
when they
before
submit
or
a plan.
during. Yeah, we're not before or during.
Typically, that's correct.
After it's done. We don't shell out
No, you complete
$3
it.
million for this plan to do this little street before anything's ever done.
The developer completes it. The city inspects it. We approve it, and then it's dedicated to us. And then,
Is that what it says?
No.
No.
I didn't think so.
See, that's the second part to my question. That's my concern, is that we're going to pay them upfront monies to do this.
Well, no, actually, no. They have to complete the Main Street.
The street.
Right.
Only.
Okay. Right.
Where does it say
And that
in
has
the
to be.
agreement?
I'm sorry.
Where does it say it in the agreement?
That they have to complete it. That is in the agreement.
That the offsite must be completed before they're reimbursed for any such offsites that they do.
Yes.
It must be completed before they're reimbursed for that.
Give me a moment. That's in Exhibit F, I believe. Preconditions for payments. Yes, page 68. It's under letter number 3. The preconditions to the payment amount are two things. One, the acceptance by the city of the completed minimum public improvements for maintenance in accordance with city standards for other public infrastructure. And then B, submittal and city approval of PDPs, that's the phased development plans, incorporating the minimum of 100,000 square feet of retail uses. So they do have to, before they can get paid, they have to do both of those things.
But that doesn't say build.
Well, the acceptance by the city of the completed minimum public improvements, that means they've built it, we've accepted it.
Okay, what gets me here is that the minimum improvements is the street only. It's a street. They're going to build a street in the middle of nowhere and submit a plan for these other things, and we have to pay them back for that street. My concern with that is what's going on the street? How can you design and build a street without knowing what's going around it, by it, under it, through it?
Those are relevant questions. I think what the proposal was hoping to suggest to you is that you would know that in terms of one of the three things that was being negotiated for, urban form, getting that, it's now a very tiny Main Street, that you would at least be assured of getting that little Main Street before any other obligations would be presented to you. But you're asking about practical things like curb cuts and sizing sewer lines, and those are all relevant.
If I could finish this line of thought here, when they go and build the street, say it's $3 million in infrastructure, and then we pay them back. 6 months later, they're going to put in, hopefully, a theater, maybe a bowling alley. It takes more sewer under the street than what they've planned for when they built it, so they have to dig it up, redo all this work, and then put it back. Are we paying for that too?
They would have to be professionals and design that line appropriately.
You can't design it when you don't know what's going there.
I would think they.
George, aren't
they'd
they
have to.
reimbursed, though, with money from the TIF, and then if it comes to that, sales tax generated by the project? So it would have to be that they have the project in place to be able to expect the money back.
Well, there would be some TIF revenue stream, even if nothing were done. But as a practical matter, I believe the answer to your question is yes. They need,
Do you want to run that by me again?
the mayor's basic question is, if you don't build something, basically you don't generate much TIF.
Or
And I
sales
think-
tax.
Or sales tax, but you could build, if you look at this conceptual plan, probably the single largest use is multifamily housing. Multifamily housing would generate TIF, but it would generate relatively little in the way, comparatively, compared to retail in the way of sales tax.
And keep in mind, it's the value of the TIF. It's not the TIF itself. It's so whatever it amounts to, that's what the city's obligated to pay. It's that amount.
Councilman Insalaka?
Well, along that same line, though, last summer, we saw pretty pictures that everybody saw. You know, they showed us what they thought the downtown was going to look like after the build-out. Has this changed, and where does the agreement, is it covered?
And now Greg will ask for help.
Because this goes in correspondence with Councilman Shieber is saying.
Could you hold that maybe up there so they can look at that? If you would look at what Greg's holding up, that's what was presented last summer. And what you have on the screen is what's being presented now. I think there's probably 5 differences, key differences that I'd highlight. There's more than 5 differences, but 5 that I'd point out. I think the one very big difference is what we showed the public last summer was a realignment of Idaho Road. It realigned Idaho, Greg, I don't know, 660 feet, something like that, to the east. The objective was to lengthen that Main Street so that you had an area that could be a pocket of pedestrian-oriented mixed use. The major challenge was if you didn't realign Idaho, you're trying to create a pedestrian-oriented mixed use downtown with a 5-lane, high-volume state highway running through it. Obvious challenge. So last summer, what they showed us called for the realignment of Idaho. Currently, it does not call for the realignment of Idaho. And while I am hugely disappointed in that change, they did so for financial reasons, and I don't find those financial reasons to being misplaced. That was a $12 to $15 million project contemplated at the time, candidly with street construction costs skyrocketing. It could have been higher than that. So Idaho Road is one change. Second major change, you'll see on the document that Greg has that Main Street extends both east and west of the current Main Street alignment. Now it would be primarily limited, as you can see on here, from North Apache Trail to Idaho Road. So it's been substantially shortened. At the bottom of this plan, you can see that the original plan last summer called for a narrowing of West Apache Trail. And the basic idea was to narrow that, what do we have, 2 or 3 lanes in each direction plus that wide median. That's a fairly substantial length to get across if you're a pedestrian. The plan you see now in front of you leaves the existing design in place. Exhibit B, the current one no longer references the student housing associated with Central Arizona College. You can see that, those brown structures right there. It's a band of white. And the fifth change that I would note, and I think it's a significant one for the council to grapple with, the new concept plan introduces big box, or I think they're calling it major retail on here. So it introduces the concept of big box development into the downtown. So Councilmember Insulaco, I don't know that that's an exhaustive list of the changes, but those are 5 key changes that I would see between what the public was shown last summer and what they're suggesting now.
Okay, but this still is not what they're proposing. This is still just a pretty picture, right? I mean, does it say anywhere in the agreement that this is what we're going to get?
No, sir.